I'm John Deaton, and your host for today. I'm still in Vegas. From the XRP conference because I have another conference in my day job, the one that pays the bills. But I wouldn't miss today's show for anything because of my special guest. I have Coinbase's Chief Legal Officer, Paul Grewal, who took the position in 2020. Before that, he was Deputy General Counsel and Vice President at Facebook. And before that, he was a federal magistrate judge, the same type of judge that you XRP holders know as Judge Netburn, who's a magistrate judge overseeing the Ripple case. So when it comes to technology and innovation and meets the law, my next guest is as knowledgeable as they come. Welcome, sir, Paul Grewal.
John, thank you. It's a pleasure and privilege to be on here with you.
No, it's my honor, sir. And I know that you get this request a lot. So I just gave the audience basically a brief historical description of your work history. But why did you take this position to be the top lawyer at Coinbase?
Well, John, when I joined Coinbase about 3 years ago, I have to say I was drawn to the opportunity in large part because I knew that this industry and certainly this company were going to be facing some of the most interesting legal issues anywhere. And I wanted to be a part of that. But my introduction to digital assets and cryptocurrencies actually goes back much further. I did, in an earlier part of my career, spend time on the federal bench as a United States magistrate judge. And it must have been back in 2011 or 2012 when I was presented with an application for a search warrant for a new kind of property, something called a Bitcoin. And I, like a good judge, not knowing anything about the subject, began to do a bit of research, and down the rabbit hole I went, along with, I suspect, so many of your listeners. So it's just remarkable to me that, over a decade later, I find myself in some of the most interesting fights involving digital assets. But it really does go back to that one day in chambers when that Rule 41 application came across my desk.
Well, and we're going to talk later about your role as a judge. I have some interesting things I'm going to show you. But first, let's talk about Coinbase. Coinbase is a public company that's registered with the Securities and Exchange Commission to issue stock, correct?
It is. That's right. In 2021, we listed as a public company for the very first time.
And so the SEC had to approve you to go public. Is that fair?
That's exactly right, John. Anytime a company wishes to list its securities on a public exchange, it has to seek permission from the SEC in order to be able to do that by filing a draft registration statement and an application called an S-1. And 2 years ago, Coinbase did exactly that. We laid out for the SEC our entire business, how we reviewed digital assets, our process for confirming that no digital asset securities would be listed on our platform. And after a ton of back and forth, lots of exchanges of information, questions, answers, productions, the SEC ultimately concluded that Coinbase should be permitted to list as a public company. And so in that very real sense, the SEC did evaluate this business carefully over 2 years ago. And it makes all that has followed since then even more perplexing.
So it's fair to say that the fact that Coinbase was going to list and trade digital assets, that didn't fall through the paperwork in any way.
No, I wish. Right? In many ways, I wish it were the case because, I'm very fortunate and blessed, John. I have a team of incredible lawyers here at Coinbase, and the entire team of lawyers worked incredibly hard on that S-1 application. And a key issue for the commission in fulfilling its statutory duty of protecting investors was making sure that our business and our process for viewing digital assets as part of our business was in the public interest. That's actually baked into the statute that establishes the SEC's authority here. And so it was not some issue that was overlooked by any means. It was a key focus for the commission and a key element of their decision to allow us to list.
Yeah, I'm a common sense kind of guy. So the way I look at it is if the SEC believed in any way that Coinbase was out there selling unregistered securities to the public, they would have never allowed approval of an IPO. Is that fair?
Absolutely right. Not only is it baked into their statute establishing their authority to allow companies like ours to list, but there's a part of the process, John, once the decision has been made to allow that listing to take place, in which a company can file for something called acceleration. It's a it's a technical issue, but ultimately it allows a company like ours to shorten the period of time beyond approval to when we actually get to list. And a key consideration in reviewing that acceleration request on top of the underlying request is this listing in the public interest? So to suggest somehow that process did not consider whether or not our business was legal and our process for reviewing assets was legal misses the mark entirely.
All right. Now, my understanding that Coinbase established a framework by which to evaluate digital assets and determine whether or not they were being offered or sold as a security, correct?
That's exactly right. It's a process, John, that we developed long before we became a public company, because we were well aware that in the absence of a path to registration offered by the SEC, we were not in a position to register as a national securities exchange and offer registered securities. And so we set about a very detailed process for reviewing each asset individually, one by one, to confirm that the guidance that we could glean from the Supreme Court in the Howey case and elsewhere clearly permitted an asset to be listed on our exchange. And so, while, as I said, it's a process that we update from time to time as we learn more about this marketplace and gain better insights into how to evaluate digital assets, that's something that was put in front of the commission over 2 years ago before we were allowed to list as a public company.
Yeah, and I want to make sure, Mr. Grewal, that I understand the framework. My understanding is that in 2019, the SEC published a framework for determining digital assets, whether they're securities. It's still on the website today. And and there it is on screen. And what Coinbase did was take that framework, make it more detailed, and assign numerical weightings to certain factors. Is that fair?
That is fair. The guidance we received back in 2019 was helpful, but it certainly did not address any and every circumstance that might apply to any particular digital asset that wanted to list on Coinbase. And so we developed our own methodology, again, working with our internal experts, working with lots and lots of lawyers at impressive, distinguished law firms to come up with a process that could work as we reviewed dozens and dozens and over time, hundreds and hundreds of assets that wanted to list on our platform. And after reviewing all of those factors that we laid out as part of our process based on that guidance, it turns out that very few assets actually make it all the way through. Something like 90% of the assets, John, wash out or fall out for one reason or another, because we have such exacting standards and are so committed to making sure that we do not list digital asset securities until we have a registration from the SEC, which is one of the reasons we find ourselves in the conversation with the commission that we are in right now.
I agree 100%. In fact, I want to show you one of the factors in that 2019 SEC
Sure.
framework. Right there, where it says, with respect to a digital asset referred to as a virtual currency, it can be immediately used in payments as a substitute for fiat. As you can imagine, most of my followers in the 76,000 XRP holders, that describes XRP itself, as well as other tokens. And my understanding is that what you all did at Coinbase was take a general framework and make it more stringent.
That's
than
exactly
what the SEC
right.
published.
That's exactly right. Well, and the SEC language, of course, is guidance. It's not a binding authority. We would like to see rules in place. We'd ultimately like to see legislation that clarifies this once and for all. But yes, we took the guidance from the SEC. We erred on the side of caution, John, because we do not want to list securities, period, end stop. And so where there was a close call, where we concluded there may be a question, we would pause on the listing and wait for further guidance from the SEC or greater clarity from the courts. It's all about being conservative and taking the longer view that if we want to build a crypto economy that works for everybody, we're going to have to be patient in certain circumstances and wait for more guidance before we can list certain assets.
In fact, what I want to do is I want to go back to make sure that the audience and the public's aware that this is no surprise. The Coinbase framework, the business model is no surprise to the SEC. I want to play you a clip from 2019. This is pre-IPO for everybody out there. And in this clip, you have Amy Starr, who is a senior official at the SEC at FinHub, and you have at the time Dorothy DeWitt, who was general counsel for business lines and markets at Coinbase. They're on a panel together. Let's just play a quick.
We implemented it. We felt very confident in the robustness of the analysis and constantly, ensure that it's constantly ensure that it's as up to date as possible, and B, run our digital assets that we list against it on a periodic basis as a part of their lifestyle management. So we did that, and we feel like we've done as robust a job as we can to work within a quickly evolving industry and identify tokens that we can list. And using that framework, we have also rejected tokens. So we have done both, and we've been transparent about that framework and the process, with our actual and potential regulators.
So again, there we are 2 years before the IPO is approved. You have senior official at the SEC, along with one of your attorneys at Coinbase, discussing the framework, discussing it. And to follow up on your point, back then, Dorothy DeWitt talked about how you reject tokens. And I think you just said 90%, Paul?
More than 90%, John. Don't pass our tests, don't pass our standards, and don't get listed on Coinbase.
All right, I want to play one more quick clip because I think this just highlights the frustration. I want to ask you a question. This is the chairman of the SEC before he was chairman of the SEC, sir.
And even for Ripple and Ether, or maybe it's, EOS or NEO or something, but for the big market cap ones, there needs to be clarity in the market.
So that was April 23rd, 2018. And so I have to ask you, you're the top attorney at the largest exchange in the United States of America. How frustrating is it for a company trying to do its best to be compliant when you're faced with this type of lack of clarity?
Well, it is frustrating, and not just for Coinbase, but for the entire industry, including, I suspect, John, many of your followers and listeners. Look, the fact of the matter is that Professor Gensler has spoken out numerous times about the marketplace. He has said, for example, on more than one occasion, that more than 75% of the market is not even impacted by a Howey analysis, because they are, in fact, not securities and therefore don't fall within the jurisdiction of the SEC. And even after Professor Gensler became Chair Gensler, after Coinbase was allowed to list as a public company in May of 2021, to the Congress, John, to Congress, Chair Gensler said that there are no market regulators applicable to cryptocurrency exchanges like ours, and therefore that Congress needed to act. So there's a long track record here of Professor Gensler and early Chair Gensler saying one thing, and as we've come to learn, later Chair Gensler taking a very different view.
And I know people are so frustrated. If we go back to 2018, when you had Director Hinman state clearly that ETH was not a security, how has it hurt innovation when the chair today won't even answer that question?
Well, you're, of course, referring to the testimony from just a few weeks ago when Chair Gensler refused to answer a simple and direct question from the chairman of the House Financial Services Committee as to whether or not ETH was a security or a commodity. It's remarkable. What's even more remarkable, John, is that in similar testimony by the chair of the Commodities Futures Trading Commission, the CFTC, you have testimony that ETH is, in fact, a commodity, not a security. So you have confusion reigning all over the place, John. It's confusion now that the federal courts are paying attention to. In the Voyager bankruptcy case, for example, the federal bankruptcy judge commented explicitly on the confusion that has been sown by regulators taking diametrically opposite views. This is no way to run a digital asset market. It's certainly not the best that this country can do. I have a lot more faith in our government and in our country than that. And yet here we are in 2023, all guessing as to whether even basic assets like ETH and XRP and a whole host of other assets are securities or not.
Yeah, it really, I served in the Marine Corps for 8 years. It really hurts my soul to honestly, to see companies just give up on the United States and go offshore.
I agree.
And I assume you're seeing that regularly in the industry.
We are. Look, John, we've run an international business at Coinbase now for many years. Something like 20% of our revenue, give or take, comes from outside the United States. We've recently announced some initiatives we've launched in places like Bermuda. We've spent time with regulators in the UK and in Dubai. But we're an American company. We were founded in this country. We were incorporated under the laws of this country. Our senior leadership was born and raised in this country. We want to see crypto and digital assets flourish here in the United States as much as anywhere else. And yet, unfortunately, the reception in our own country is much more hostile to digital assets, much more hostile to crypto and crypto payments than anything we're seeing in any other country around the world. And so we have to pay attention to that difference and react to it accordingly.
All right, Paul, I want to talk about something that's part of the public record. It's something that I made a big deal about in my amicus brief. So I have to ask you whether or not you're limited in answering. I don't know, but we know that Coinbase literally went out of its way in January of 2019, met with the SEC. Again, this is public record, that to discuss XRP and the potential listing of XRP. And after that meeting, a month later, XRP got listed on Coinbase. And so I'm just have to ask you, is there anything that you can share with us about that January 2019 meeting, or is it because of potential litigation you just can't comment?
Well, John, unfortunately, I can't get into the specifics of that meeting. What I can say is that your timeline is correct. And I'll let you draw the conclusions from that you deem appropriate.
Well, I'll tell you something. It's like I said, Coinbase has been known from the beginning to go the extra mile of being a public company, scrutinized by the SEC. I know you can't talk about the meeting, but it is a fact that 1 month later, Coinbase, after that meeting, listed XRP. I'm assuming that in 2019, Coinbase did have a vision of going to issue an IPO thereafter. In fact, I want to show something that when I became a Coinbase customer, what I saw on my phone, if we could pull that up. Here we had, not only did Coinbase list XRP, it was adopting XRP's utility along with USDC as far as being able to move money cross borders, Coinbase customer to Coinbase customer. And so it's fair to say, I know you can't comment, that you certainly weren't dissuaded from listing XRP.
Well, I should say that in 2019, John, it was still very much, I think, an open question whether Coinbase or any other cryptocurrency company would be allowed to list as a public company. And so while like a lot of entrepreneurs, our company and its leadership had dreams one day of achieving that goal, I can't say it was something we had firmly in hand or firmly in mind at that point in time. As to whether or not it would be a reasonable conclusion to draw from the timeline that you've laid out, that we were confident in our assessment and confident in the commission's comfort with that assessment. Again, I'll leave it to you to draw whatever conclusions you deem appropriate.
Well, thank you. So let's talk about something very important that ignites strong feelings within the XRP community. Coinbase, along with other exchanges in the United States, based on the Ripple case and the nature of the allegations in the Ripple case, made the decision to suspend trading of XRP. And I would assume, I wasn't going to get involved at all in any of this because I assumed, even though I was an XRP holder, that the allegations, Paul, would be Ripple on this particular day offered and sold an investment contract when they sold XRP on that specific day, that specific circumstances and transaction. But instead, they implicated all sales of XRP. And so I went on record to say that 90% of attorneys would have recommended Coinbase or Kraken or anyone else to suspend trading. So my first question is, did I underestimate the 90%?
Well, I can't speak to a specific percentage, but I think it's fair to say that, look, we take any allegations from an important regulator like the SEC seriously. And so, that certainly was something we paid very careful attention to. At the same time, we were very explicit when we made our decision that we were pausing our listing. We were not making a final determination. And I can say this much, John. We are paying as much or more attention to the goings on in Judge Torres's court as anyone on the earth, because we're very eager to see clarity finally brought to the marketplace, and the confusion that has been sown by the SEC's very expansive view of primary and secondary sales as being implicated by its allegations. We want to see that confusion addressed once and for all.
Paul, would it be fair to say that because Coinbase is a publicly listed company that's subject to significantly more regulatory scrutiny, that that plays a part in whether or not that decision to suspend trading of XRP because you got shareholders, fiduciary issues, things of that nature?
Well, we certainly have some unique responsibilities as a public company. We take those responsibilities very, very seriously. At the same time, John, we are eager for the courts to finally resolve some of these open questions that the SEC has either refused to engage in or has only made more confusing by allegations that seem completely at odds with the precedents of the courts and the plain language, frankly, of the statutes passed by Congress. So, yes, as a public company, we do have some unique responsibilities and some particular sensitivities to those issues. But one thing I want to assure you and assure all your followers is that this is not a decision that is set in stone. And once the courts issue sufficient clarity in the form of a ruling or a decision, we will not hesitate to revisit that issue.
Well, everybody knows by now that I'm not an XRP maximalist. I'm not a Bitcoin maximalist. I call myself a crypto maximalist. I want people to understand that the enemy here are not American companies who are being affected by the SEC's war on crypto or their lack of clarity. That it's the SEC's enforcement by regulation by enforcement that's the real enemy here, and not Coinbase, not Kraken, or some other company that faces legal consequences. Let's shift gears to talk about the Wells notice that Coinbase received from the SEC and what that means.
Yeah, well, a Wells notice, John, as you well understand and know, is simply a formal notification from the SEC to an individual or to a company that it has reached a preliminary determination that one or more federal securities laws has been violated. And what it does is it kicks off a process by which the individual or company accused has the opportunity to respond and to attempt to persuade the enforcement division staff and ultimately the individual commissioners that a case would be misguided or contrary to law. And so, having received that Wells notice, we have proceeded to submit a brief which outlines why we think a case against Coinbase would certainly be contrary to law. And then we also submitted, John, which I believe was a first, a video which also elaborated on some of the points that we made. And one thing that we did for each of these elements of the Wells process, the notice, the brief, and the video, was we shared it with the public. And we did that very consciously, John, because it was very important to Coinbase that the public be able to assess for itself whether the SEC was playing it straight and laying out its concerns in plain English in an intelligible manner, or whether we were somehow characterizing that in some unfair way. And we also thought it was important for people to hear how we responded in the literal terms of the brief and in the video, so that people could, again, reach their own conclusions on whether we were somehow playing fast and loose or whether it was the commission that was playing fast and loose. And again, I invite all of your listeners, if they haven't already had the opportunity, to go on the web, go pull up the Wells submissions and make decisions and conclusions for themselves. I think they're going to be pretty clear once they've had a chance to review them.
I loved the video. I tweeted it out and I said, I paid you and Brian Armstrong a compliment. I said, as far as you are, Paul, that's the way you make it firm, that you will defend yourself at all costs, but at the same time, extending an olive branch to say, we don't have to go down that road. Let's talk anywhere, any place. Loved it. Now, I got to tell you, I'm as an investor, as a public person, as a public investor investing in companies, I've become aware of this modus operandi of the SEC. I've talked to the library CEO. I've talked to other companies that have not made public, where the SEC people have taken Gary Gensler on his word and said, okay, you want me to come in? We're going to come in. And all they do is tell them their business model, give them all this free discovery, if you will. And then They get no guidance, and all they do is get a Wells notice or they get a complaint issued. And so we even saw Gary Gensler, Jesse Powell had tweeted out when Gary Gensler said, there's a form on the website. I don't know if you saw that, but can you speak to that? Because I know you've had 30 meetings with the SEC.
We have, going back to July of last year, John, we filed a formal petition for rulemaking in which we asked the SEC something like 50 questions that we thought needed to be answered and requested that rules finally be presented that the industry and that individuals could follow without any confusion, without any uncertainty. That request back in July was followed on by a series of comments that we submitted to our own petition. And importantly, John, over 1,700 comments from other people interested in the exact same issue, all eager to see fair, reasonable rules issued that would protect investors, that would hold exchanges like us and issuers accountable for any untoward behavior. And the response to the petition, all those comments from the SEC was silence on the one hand, and on the other hand, a threat of litigation in the form of the Wells notice. So that has proven to be quite frustrating. That said, John, we didn't just rely upon our public advocacy. We did have over 30 engagements with the SEC privately over a similar period of time, trying to work with them to find common ground on what a registration process could look like and what sensible rules for registering as a national securities exchange might be. And after we presented all of our ideas, after we exhausted all of the questions that they asked of us, when it came time for them to give us a response, to tell us what they thought might work, they simply told us to have a nice day. And the Wells notice came a short period of time after that. It was remarkable.
Now, I want to play a real quick clip from that 2019 consensus where Amy Starr is at the SEC. She makes a comment that I want to share with you.
Through it, and then we sit down and we say, okay, we've got all these kinds of questions. And we'll put together a list of questions. And then 2 or 3 staff will get on the phone with counsel and with the company and walk through them. We don't put anything in writing.
When I heard that, at the time, I was like, there we go, where we're just going to keep it vague. And so 30 meetings with the SEC. Do you have anything from them in writing?
The only thing I have in writing from them, John, is the Wells notice that I've shared with you and shared with the rest of the world. And I want to be very clear about one thing, John, because I do think sometimes this gets lost in a lot of the passionate rhetoric that we're all guilty of from time to time.
Yep.
SEC, contrary to the belief of some, is full of good people, patriots, trying to do the right thing in almost every instance. The problem isn't with the staff. Yep. The problem is with the political leadership. And in this case, the chair, who has made it very clear that he's not interested in providing clear rules to this industry. He's not interested in protecting investors while promoting innovation. He's interested in something very different. And once that became abundantly clear, frankly, we were left with very little choice but to make it known to the commission that while we were prepared for further conversations, we'd always keep an open door and an open mind. If this thing has to go to court in order to be resolved, we are prepared to do that. It's really that simple.
And you did something which I loved, of course, and my audience, of course, knows what a writ of mandamus is. Most other people.
Thanks to you.
And Coinbase filed a writ of mandamus, which basically they know is basically asking a judge to force someone to do their job, right. An official to do their job. What's the goal for you on Coinbase with that writ?
Well, even as we've attempted to resolve the concerns to the extent they've been articulated by the SEC through this Wells process, we remain, waiting for an answer to our petition now 9 months or more into the process. And so we did file our own petition for a writ of mandamus in the Third Circuit Court of Appeals. And our request to that court was actually pretty simple. Please, with all due respect, order the SEC to give us a simple yes or no answer to our very simple yes or no question, which is, will you issue rules? And here's the thing, John, the law is explicit, and you know this very well, you're a practitioner in this space, that the SEC has to act reasonably in considering any petition. Well, reasonable means different things to different people, but one thing is abundantly clear. Telling the world that no rules are coming, which is what the chair has done and what the commission has done in other settings on the one hand, but refusing to tell Coinbase and our 1,700 fellow commenters that same answer in a formal way that would allow us to go to court and challenge that decision on the other. That's not reasonable. It's not reasonable to hold on to that decision at the same time as you've unleashed a campaign of regulation by enforcement or threatened enforcement. And it's also not reasonable to do that at the same time as Congress is clearly moving towards adopting legislation on things like stable coins, on things like market structure, that would provide finally some clarity to the market and some certainty for investors all over the country and around the world. So we think there is a compelling argument in this case that the SEC should have to answer. That will ultimately be up to the court to decide. But we thought, again, it was important to put these issues out into the public so that everyone could understand exactly how their government was acting and what the implications for their country might be.
I want to talk about this war on crypto. I have to ask you, you're way more in tune than I could ever be. You're talking to politicians and leaders and other businesses. Why do you think this war on crypto is happening now?
Well, John, speaking to a veteran such as yourself, I have to say I'm always more than a little bit reluctant to invoke war metaphors, because as a civilian, I think that sometimes we abuse the privilege that we have working in industries like ours when wars for many others are not a matter of choice. But we are certainly in a fight. We are certainly in a fight here. And it's clear to me that this fight against crypto that has been declared by the government is not some figment of our collective imagination, right? You only have to look at the clear and irrefutable evidence before all of us to see that for a certain portion of our government, crypto is something to be eradicated or stamped out in this country, not something to be nurtured and developed. And I say a portion because I also want to be clear, John, there are parts of our government, even our federal government, that I think have a much more constructive view. The CFTC, for example, the Department of Treasury, even the Department of Justice. John, federal prosecutors are not pushovers. These are tough customers by and large. Yep. Even they have taken a measured, balanced approach. And yet we have in the Securities and Exchange Commission and in certain portions of the White House and the banking regulators, a misguided sense that somehow crypto is something that needs to be pushed off our shores and into the dark corners of the modern economy. We think that's a huge mistake. I can't speak to anyone's motives, but what I can say is, John, we're putting at risk committing yet again the same mistake we make, unfortunately, over and over again in this country, which is we develop technology, we come up with the great ideas, we nurture an industry to the point where it really does transform how we all live, and then we send it overseas only to lament 10 years, 20 years, or 30 years later, how did we lose this?
Yep.
Right? I just hate to see us make that same mistake again, but it appears for at least some that's a mistake they're eager to make again.
Yeah, it's unfortunate. So I have to ask you, because I know that you deal in DC quite a bit, or at least spend some time there. Will it be the courts that give us the answer, the central legal question around crypto and classifications of digital assets, or do you think Congress will step in before the courts, appellate courts, make a decision?
Well, look, the legislative process is certainly slow and often, subject to forces beyond certainly my pay grade in terms of understanding and control. But look, I am an optimist that there are members of Congress who understand these issues, who want to get it right, who want to see America continuing to lead. And so we are investing a lot of time educating lawmakers and providing assistance and insight to the extent it's useful to help them draft legislation that will get us there. In the meantime, though, John, if there's no other place to go, the courts are always the part of government that's the last resort for people seeking justice. And whether it's Judge Torres, whether it's the Second Circuit, whether it's the Supreme Court, I can't say, but I do think we're going to get clarity one way or the other, even if it's going to take us all. Even if it's going to take a lot longer than any of us would like.
Sure. I want to talk to you now about why I'm even here. And I'm here for one reason and one reason only. And the only reason I get to interview is secondary market sales. I a lot of people classified me as the XRP attorney, even though I made it clear I own more Bitcoin and even own more ETH than I did as far as XRP. That had the SEC said the same allegation against ETH, I would have acted the same way, and I'd represent ETH holders instead of XRP holders. But had the SEC limited the allegations to Ripple and Ripple cells, I just wouldn't be here. And in fact, when I filed my motion, the SEC came up with this theory. And I want to share with you, you probably have read this already, but this is their response to my motion when I wanted to get involved. And they said that the XRP traded even in the secondary market is the embodiment of those facts, circumstances, promises, and expectations, and today represents that investment contract. Now, if you notice, as a federal judge, will you be struck when you see that there's no citation after that sentence?
Always, John. My antenna go up, to put it gently, whenever I see an assertion as broad and as unqualified as that one, with no supporting citation or evidence or case law to point to at all. And I have to just to comment a bit on the substance of the claim. It completely ignores, John, what the Supreme Court said in Howey, which is before you even get to the 4 factors that we all know so well: investment of money in a common enterprise, all of that. There has to be what? There has to be a transaction, a contract, or a scheme, right? That's in the plain language of Howey. Where on earth is there any transaction, contract, or scheme applicable to the parties in a secondary market transaction? There just isn't one. And no serious scholar would, or lawyer or student of this area would claim otherwise. It's a remarkable thing to read in a brief submitted to a federal court.
No, it is. And it struck me, obviously. In Coinbase, in their Wells notice response, discusses secondary market sales and what you and I have just went over, and how it just doesn't meet the Howey test anyway. And I have to talk to you. I want to share with you, because I'm sure, and get your response. The people I represent, XRP holders, every argument that you're making about secondary sales equally applies to XRP. And yet XRP was suspended. And then we see a case against Bittrex where the SEC says algo is also a security. And of course, there isn't a suspension of that. And so do you understand where, as an XRP holders, that they get frustrated or even angry that they're penalized? Not that anyone wants you to delist algo or suspend algo. Let me make that clear. I just don't know what's your thoughts on that, sir.
No, I do understand that frustration. And look, I get it. People can be passionate about these issues, and the rhetoric can sometimes get heated. But I understand where folks are coming from, and I also can understand why it can feel like there's a double standard that's being applied in a variety of circumstances. The law evolves, circumstances evolve. As the chair himself likes to say, facts and circumstances constantly change. But I can understand where that frustration is. At the same time, I want your listeners and followers to understand we are committed to applying the law and standing up for the rule of law for everyone, including holders of XRP. It's one of the reasons, John, that we submitted an amicus brief in the case against the Ripple defendants, in order to support one of their particular defenses, the fair notice defense that was raised, which I think ultimately is something they could and should win on at trial if it gets to that. Others spoke to some of the other issues, including the secondary markets point that you've raised and been such an articulate voice on now for many, many months. I think the main point, John, for all of us is that this is a team sport we need to play. We're up against the most well-resourced adversary on the entire planet. That's the United States government, and in the form of the Securities and Exchange Commission. We've seen now, as you've highlighted, they're not above misstating the law and offering assertions without support if it helps them achieve their objectives. Again, I don't question the motives of the staff, but I do think there's some powerful political forces here that require that we all work together, that we find our common ground, and that we claim our government back for ourselves, and not allow this, one single part of this one regulator to run roughshod over something we've collectively worked 30 years for as a country in order to build.
No, I appreciate that. We're going to wrap up, but I would be remiss to not ask you about something. At Consensus, I had the pleasure, I had a small dinner gathering, and Caitlin Long was part of that. And I realized that I, as someone who's been involved in the litigation and this battle, that even I was underestimating the banking issue. And we know the choke point 2.0 as it's been described, and that the industry is facing this banking issue. We saw it with Signature. Caitlin Long with Custodial Bank has this revolutionary idea of 100% reserves that's being rejected. And what are your thoughts on that issue? Because it's something I need to start paying more attention to myself.
Well, I think we all need to be paying a lot more attention, John, to what's going on with the debanking of so many in crypto. Look, the fact of the matter is, if the SEC or anybody else truly believes that a particular asset or a particular product and service is a security, and wants to challenge a company or an individual on that basis, articulate that, file a case in court, let's litigate this, and let's all live with the final determination of the U.S. court system. I think we'd all be very comfortable and confident with that. What is much more nefarious, and what I believe much more dangerous, is this practice of quietly discouraging basic services from supporting different participants in the crypto economy in a way that denies them any opportunity at all to defend themselves in a fair fight, right? If you don't have oxygen, John, if you can't breathe, you're not much good in the ring. And for firms like many in crypto, access to banking services is the functional equivalent of oxygen. And so what regulators unfortunately seem to be doing is looking for ways to cut off that oxygen supply so that the Caitlin Longs and others of the world aren't even in a position to fight what they're trying to do in plain view. So I do think it's something we all need to pay a lot of attention to. It's yet another reason, John, why Coinbase just a few weeks ago announced something called Crypto 435, which stands for the 435 congressional districts across the country. If your followers are at all interested in lending their voice in a different way to this debate, whether it's on debanking, whether it's on the overreach of the SEC, they can go to our Twitter feed. They can find a pinned tweet with all the information on how to get involved, learn how to contact their legislators, get involved in any way they want to or can, because this is a fight that we all need to be a part of, even if we have our own particular interests ultimately in mind.
No, I agree. And listen, I've fought for transparency, so let me be transparent. I am a Coinbase customer, and I actually have I own shares in Coinbase, so I want everyone to know that. I'm a fan of what you're doing. That doesn't mean I have to agree with everything that Coinbase does, or that you say. You don't have to agree with everything I say, but you are 100% correct. We are on the same team. And if there's anything I can ever do to assist Coinbase, I'll be right there. And I want to thank you so much for taking the time, Paul. Appreciate
John, I want to say thank you, not just for this opportunity, but for all that you've done for all of digital assets and crypto. You're a leading voice in this fight, and we're all lucky to have you as part of it.
Thank you so much. I appreciate that. Have a great day.
Thank you.